Ms. Lee.
Madam Chief Justice, and may it please the Court, my name is Jin-Hee Lee, and it is a great honor to appear before you on behalf of the NAACP Legal Defense and Educational Fund, which serves as amicus curiae in support of Mr. Burke in this case. The Legal Defense Fund represented Warren McCluskey when the United States Supreme Court issued a decision in McCluskey v. Kemp, a decision that has been widely criticized as the Dred Scott of our time. But today, this court has the historic opportunity to do what the United States Supreme Court declined to do 32 years ago. And that is to take seriously the very urgent task of rooting out racial discrimination from the administration of the death penalty, and to secure public confidence in the judicial process by making absolutely clear that racial discrimination will not be tolerated by the courts of North Carolina. That was the very purpose of the Racial Justice Act when it was passed by the General Assembly in 2009. It was a recognition that the judicial system had not fully eradicated racial discrimination from North Carolina's capital punishment system. And it was an assurance to the people of North Carolina that no person in this state would be executed if race was a significant factor in his or her death sentence. In repealing the Racial Justice Act in 2013, a subsequent General Assembly turned its back on that very important commitment to eradicating racial discrimination from the death penalty in North Carolina. And this is the same legislature that was found by the Fourth Circuit Court of Appeals to have intentionally discriminated against African American voters by passing voter suppression laws that targeted them with what the court said was surgical precision. And it is also the same legislature whose very legitimacy is in question because of unconstitutional partisan gerrymandering. But regardless of what the 2013 General Assembly did, this court has the authority, but also the responsibility to allow Mr. Burke to pursue his very powerful claims of jury discrimination. And that is why we urge this court to order an evidentiary hearing so that Mr. Burke can pursue those claims. And it can do that in three ways. One is to allow him to pursue a traditional Batson claim, as Mr. Hunter had just argued. Secondly, to find that the retroactive application of the repeal of the Racial Justice Act to be unconstitutional under both the federal and state constitutions. But independent of the whole issue of retroactivity, this court has a separate and independent authority to enforce Article 1, Section 19 and Section 26 of the North Carolina Constitution, and especially Section 26, which expressly bars anyone from being excluded from jury service on the basis of race. It's especially important for this court to act in Mr. Burke's case because of the very deeply troubling evidence that he proffered when he filed his Racial Justice Act claim in 2010. Mr. Hunter mentioned some of the statistical evidence. I mean, that evidence is astounding. For prosecutors for black jurors to be struck, the likelihood of them being struck to be 11.8 times more in capital cases in prosecutorial District 22. I mean, that is an astounding fact. But even looking at all the other geographic divisions, whether you look at it statewide, by judicial division, by county, the evidence shows that prosecutors were striking black jurors they were over twice as likely to strike black jurors in capital cases. But Mr. Burke presented more than just statistical evidence. He also presented direct evidence of racial discrimination in his specific case. There's evidence that the prosecutors in his case deliberately struck African American jurors on the basis of race. And one prominent example was the peremptory challenge that was exercised against Vanessa Moore. And this was evidence that was noted by Judge Weeks in his opinion. And he found that that was actually an example of intentional discrimination by the state. Ms. Moore is a black woman, African American woman, who is a citizen of Iredell County, and as a citizen of Iredell County, had the right to serve on a jury as an exercise of her citizenship. And she was struck by the prosecution, and the race-neutral reason proffered by the state was the mere fact that she had lived some part of her life outside of North Carolina, in the Maryland and Washington, D.C. area. And they proffered that as a valid reason, despite the fact that Ms. Moore was born in Iredell County, had gone to school in Iredell County, and had lived in Iredell County for the prior 8 years, and also despite the fact that the prosecution accepted 4 white jurors who had also been either born or lived outside of North Carolina, and 3 of whom had lived in North Carolina for only 4 years. So using the peremptory challenges in a discriminatory way and striking 3 of the 4 available black jurors in Mr. Burke's case, the prosecutor was able to secure an all-white jury. And to this all-white jury, the prosecution argued that Mr. Burke was a big black bull in closing arguments. That's astounding, to use such racially inflammatory language under any circumstances, but against an African-American defendant sitting in judgment by an all-white jury. And how can the public have confidence in a judicial process where this is allowed? And especially in a community like Iredell County, which at that time had experienced tremendous racial tension in that community. Just a decade before Mr. Burke's own trial, there were at least 12 incidents of racially motivated violence in Iredell County, which included cross burnings and gunshots in the homes of African American families and biracial families. In 1993, the same year that Mr. Burke was tried and convicted and sentenced to death, public officials in Iredell County allowed the Confederate flag to be flown over the Iredell County courthouse. Even as recently as 2012 and 2015, there has been evidence of Klan activity in Iredell County. This is the context. This is the community in which a prosecutor deliberately excluded African American citizens from jury service, secured an all-white jury, and then argued that the defendant was an African American defendant was a big black bull. And this directly implicates this court's authority to enforce Article 1, Section 26 of the North Carolina State Constitution, which is it's such an important provision. It has no federal counterpart. It's a declaration by the people of North Carolina that jury service, to be on a jury, is such an important and integral part of citizenship and democracy in this state that it had to be protected by the state constitution. And unfortunately, despite the importance of this constitutional provision, it has not been fully enforced in North Carolina. In the 33 years since the United States Supreme Court issued its decision in Batson v. Kentucky, North Carolina appellate courts have not once found purposeful discrimination against a juror of color in the exercise of peremptory challenges. Not once. And that record is astounding on its own. But when you compare it to the sister jurisdictions in appellate courts all across the South, in Alabama, there's been at least 80 Batson reversals. In South Carolina, more than 12 times has appellate courts found purposeful discrimination. In Mississippi and Louisiana, at least 10 times. In Georgia, at least 8. But yet in North Carolina, not a single instance has an appellate court found purposeful discrimination against a juror of color in the exercise of peremptory challenges.
What's your response to the state's argument on that point, that that's because our trial courts are doing such a good job?
Well, I think that argument is belied by the statistical evidence that was presented in in the Cumberland County cases, but proffered by Mr. Burke as well. Because what we find is that African Americans are more than twice as likely to be struck by prosecutors. And then even when you control for race-neutral reasons, that it's 11.8 times more likely in prosecutorial District 22. I mean, those are astounding facts. That shows that there is a problem with jury discrimination all across the state of North Carolina, but also in individual subdivisions, in individual judicial divisions, as well as prosecutorial districts. I want to end by saying a few words about State v. Keith, which has been discussed at length by prior counsel who've already argued here. And as they've noted, it is the only other time in this court's history where it has been presented with facts similar to the retroactive repeal of the Racial Justice Act. And in effect, this court would have to repeal State v. Keith in order to deny Mr. Burke the ability to pursue his jury discrimination claims under the Racial Justice Act. And under those circumstances, it would be a tragic irony for this court to rule in favor of a Confederate officer who is responsible for the massacre of 13 men and boys aged 13 to 60, shot at point-blank range, 5 at a time, and yet rule against an African-American man sentenced to death by an all-white jury, called a big black bull by the prosecution to this all-white jury, and who has presented powerful evidence of jury discrimination in his case. Thank you.
Thank you.